Paragraph 16 of affidavit, supporting affidavit, will not rely on it. And paragraph 10 of the same affidavit will not rely on the same. But the standard, your lordship, is that of a bystander. Ahmed Nasir spoke, and he has a following of over 1 million on his Twitter handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is constituted for a particular mission, 3, it's part of the conspiracy. Your lordship, we urge you to uphold our application and grant the prayers sought. Your lordship, my learned friend Mr. Masharia will highlight on the authority with the authority in support of my submissions and those of Kibe.
A slight clarification on expansion. Paragraphs 10 and 16, if I had properly.
Yes, that's correct.
Of the supporting affidavit.
That's correct.
I don't know whether we can do that through oral submissions. You cannot expunge a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number 2, if you expunge paragraph 16...
Can you cover it in your response, please?
I may, but if you expunge 16, I have a problem with that. There is no application before you. If you expunge paragraph 16 from the affidavit, there is no application as being urged before you. So we need all this clarification. Let's not take things lightly.
Yes, Your Lordship, yes, it is true that the paragraph that I seek to expunge is paragraph 16.
I would like to address the question. I would like to address the question.
Paragraph 16 of which affidavit? By who?
Who's affidavit?
And 16 is
the applicant's affidavit. That is Obuli Namenya.
This is 10, 16
My Lord, permit me with
perhaps, my Lord, again, because we have to be fair to the court, my colleague has to be candid and confirm to the court. The reason is withdrawing that paragraph 16 is because the claim there is factually false. Because you can't just withdraw and leave the world thinking...
We are not even seeing that paragraph 16. Can you read it, the paragraphs we want to withdraw?
And 10 and 16.
Your Lordship, are you having the same application?
Read as paragraph 10, which we want to withdraw, and paragraph 16, so that we can consider if it can be withdrawn.
Yes, paragraph 16.
Confess it's a lie.
We give Mr. Ndegwa, my lords, your leadership, the opportunity to finish his sentence.
Yes, yes. Let him read those paragraphs,
yes,
so that we can sit down.
No, I agree. I'm just saying, protect him from these tutorials that he's getting from this side.
Order. Please read as paragraph 10.
Your Lordship, I wish to say that most respectively, I wish to say no more in respect to the paragraph.
This is a direction from court. Read paragraph 10 and paragraph 16.
Paragraph 16 reads...
Paragraph 10 first.
May I have some peace, Your Lordship?
No, listen.
How
please.
many people are in
Please,
conduct
please,
of these
please
trials,
listen.
Your Lordship?
Listen.
Who is in conduct?
Listen. Bana Njiru,
Yes, Your Lordship. I'll read.
you have applied to expunge
Yes, Your
paragraphs 10 and paragraph 16.
Yes, Your Lordship.
Can you read those paragraphs which you intend to expunge?
Your Lordship, paragraph 16 says that...
Paragraph 10.
Do I have to read it out format? And Your Lordship, may I take note that these paragraphs have been expunged? One,
We have not expunged those paragraphs.
that
It
I
is
have
your
made an application to
application.
expunge them. The petitioners have credible information that Honorable Mrima is a close associate to the proposed Deputy President, one Mr. Kithure Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expunge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is convicted as she should recuse herself, as she was Mr. Kithure Kindiki's LLM student at Moi University.
We have no LLM program at Moi University.
You will have your time to submit, sir. Stop itching. And that's why I'm expunging it. That's why I'm expunging this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
We have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about?
In a ruling, because application has been made and the response is there, but we decline the invitation to expunge those paragraphs. They will remain as part of the record.
My Lord, will you permit me to address you?
Dr. Kamona, we would appreciate if you want to address us in the course of the as in you are submitting. Is that the position?
Yes, that's about it.
Okay, proceed.
Yeah.
What is the position?
My Lord, my position is this. Is that if there is a party...
Are you supporting the motion?
I'm supporting my land friends for complaint to Ndegwa and Chiru and my land friend Mr. Kip.
You need to go.
Hmm?
Yes, you go first.
Oh, you want to go first?
Yes. This one feels
You have a prejudice if I talk?
Yes.
Thank you very much to my senior. My lords, I'll take about 15 minutes. Mercifully, my issues are issues of law. They will not incite any shooting up from my respondents, or should not. My lords, my lords and your ladyship, I have submitted some two cases. The first case is the case of Standard Chartered Financial Services and another versus Manchester Outfitters. I don't know that you have that with you. And the second is a case called Naveen Premjikerai versus Virunga Limited and others. In the case of Standard Chartered Financial Services Limited versus Manchester Outfitters, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set it aside and varied it. And the only question before that court that led it to this decision was the question of bias. I invite my lords and your ladyship to paragraph 1 of the decision, where the court says as follows in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declared nullity, set aside, and the appeal heard afresh. I invite you now to go to paragraph 9. We've done back-to-back photocopying, but if you look at paragraph 9, in the middle is in bold the words Jasbir Singh Rai and two others versus Talukan Singh Rai. And the court is saying what it held. And it says this. During the pendency, my lords and your ladyship, are you there? In the middle of paragraph 9. During the pendency of the applicant's motion and the respondent's preliminary objection, this court in a 5-judge bench decision in Jasbir, and they give the whole case there, held inter alia, that it was only mandated to hear and determine appeals from the High Court and could not revisit its own previously concluded decision, nor did it have powers to reopen and rehear a finally concluded matter. In light of the decision in the Rai case, it was deemed appropriate that since this matter raises